time, they worked very hard to try to preserve aspects of the juvenile court that they and society believed were good. Unlike many people who made an argument and voiced concerns that having counsel could change the process, taking away the advantages of having a juvenile court, the justices believed the opposite, that counsel would actually help the child understand the process, help the judge individualize treatment for the child, and that without counsel, the child could not maneuver the process or bring forth the information that the judge would need to make the appropriate decisions. The juvenile needs an advocate that can speak to the court for him, help his voice be heard, and assist the child in achieving his or her goals. But this is just the first step in the process, giving children the right to counsel. And this is where I think as child advocates, as lawyers, as judges, we missed the boat. We missed the opportunity. So 40 years later, we're looking to see, are we there yet? Do children have the protections that they should be having in juvenile court? Although the Galt decision should have provided these protections, and they should have given children a more active role in the proceedings and a stronger voice, I don't believe that it actually has. And rather, what we did was we modeled the juvenile system after the criminal system, taking all the bad of that system and putting it into the juvenile system. And we had the opportunity to create an attorney-client relationship that would be different and better and actually give more protection to juveniles. Although the Galt decision gives the right to counsel, it's also a very narrow decision. It only talks about it in relation to one part of the process. It doesn't talk about all the other things that come and are involved with the right to counsel. So you need to look at when this attaches, what ethical obligations lawyers might have to children, who is the client that the attorney is representing, indigency determinations, how waiver of the counsel might apply in juvenile court, and what's the appropriate role for counsel to take in the juvenile court proceedings. So in the time that I'm allotted today, I'm going to just briefly, because we don't have one yet, skim over some of these issues. First, I'm going to look at when the right to counsel should attach. And it's true that Galt only talked about the adjudicatory hearing as far as the holding. But they did not ignore the fact that counsel was important in other aspects of the juvenile proceeding. They talked specifically about the dispositional phase. And they made note that an attorney can play an important role in the process of rehabilitation. They also talked about the President's Crime Commission and recommended that counsel be appointed wherever coercive action is a possibility. This supports the argument that children actually need counsel at every point of interaction with the system. From the time that the child is questioned by the police, they need to have the protection and the advice of counsel. Because all of this is actually a coercive action, particularly when you're talking about children. So they need it then in the initial interaction with the police, they need it at the intake process, they need it at the adjudicatory and dispositional hearings, they need it for appeal, and they certainly need it for post-dispositional hearings. Many of these phases, states do not look at applying counsel. And that's part of where, as lawyers that are representing children, we should be advocating for a stronger support system for children who are coming through the legal system. Galt's case certainly illustrates the need for counsel at every stage in the proceedings. Certainly, if Gerald had an attorney when he was first questioned by the police officer, he might not have been detained at all. He was initially asked by the sheriff who came to his house if his brother was home, because the phone that they used to make this phone call was in his brother's name. When he said that his brother wasn't there, and Gerald was the only person in the home at the time, the sheriff took him off to the detention center.
Tell him what Gerald did.
At which point?
Why they went after him.
What he said.
What he said. Tell him what he said. What he said. the lady who complained about it.
Go ahead, because the sheet is someplace else with
It's
it.
very, oh, I'm sorry.
No, go ahead.
I hope I remember it now after all this. The person, the anonymous caller said to the lady, it was alleged to be Gerald, do you give any, which I don't quite understand, you still have your charity, which I understand even less, and something about her boobs, and that was
A balloon phone call.
a lewd phone call, which was a crime only if you did it in front of women and children.
This is all part of the legend because Gerald, of course, was innocent and doesn't know himself.
Right, that's what I was going to get to.
The other part is he said, big bombers, Mrs.
Oh,
Cook,
bombers, yes.
or nice hooters, Mrs. Cook.
But, first of all, there was no record, so we don't actually have all of it. And Gerald has a different story to tell. So once Gerald was taken into custody, and he was taken down to the detention center, the shelter, you would hope that he would have an attorney at that point for the detention hearing, for the adjudicatory hearing, where the attorney might have been able to protect his rights, made sure that the complainant came forward, prevent the judge from questioning Gerald directly, and in addition, being able to advocate for Gerald, to make sure that Gerald's story was told the way that Gerald wanted it told and that he believed to be true. Although Gerald's parents believed in him, they did not know the system any better than he did. And just like the young girl in the video said, parents not enough. You need a lawyer. And you need a lawyer who's trained in juvenile law. So even if your parent's a lawyer, that's not the lawyer you want down there. Gerald didn't know what information to bring to the judge's attention. And when you read the case, you read also that it wasn't just Gerald Gall that was there, but there was another young man named Ronald Lewis. And if you ask Gerald about his friend and co-defendant, people get very angry to this day, 40 years later. Actually now 43 years later, because the decision took 3 years to come down, right? Gerald and Ronald were friends. He was at his house. Gerald's not denying that Ronald was there. Ronald wanted to make a phone call. Gerald had no idea who this phone call was being made to, but he did know that his family did not have a lot of money, and he was concerned that Ronald might be making a long-distance phone call. So he said, fine, you can call who you want, but you give me the number, I'm going to dial it, so that I know it's not a long-distance call. And that's all that Gerald did, dial the phone number. Okay? Later on, although Ronald may have been brought in at some point, Ronald was also whisked off in the middle of the night to California, to where his mother lived, and never actually charged with these events because his father worked part-time for the sheriff's department. And Gerald believes very strongly to this day that who you know is much more important than what you did. And that still plays out today. So if Gerald had a lawyer that could have brought some of these things out, maybe Gerald would have ended up with a better feel about the system and the fact that really the people in that room had some concern about him and not just making sure that somebody was punished. Again, we would hope that an attorney would argue the case to the judge so that Gerald would not get a sentence that amounted to 6 years in prison. Also, if Gerald had an attorney, the attorney could have looked over the record that they would have demanded would sit in place and a basis for an appeal. Instead, we have Gerald's father visiting him in the detention center as he's awaiting to be sent to the industrial school and asking Gerald what he wants to do. And Gerald, being 14, 15 years old at the time, says, well, I guess I must have done something wrong. They say I did, I don't know what it was, but I guess I have to do what they say. I guess I'm going to this school. And Gerald's father didn't want to